the introduction to the House of this legislation, and I thank Minister Richard Bruton and Jed Nash for their work in bringing it forward. I have been quite concerned over the past number of years at the lack of a statutory framework to ensure that workers seeking to improve their terms and conditions can do so, whether they seek to engage in collective bargaining or through a registered employment agreement. The latter being particularly important given that the Supreme Court struck down the old registered employment agreement framework on constitutional grounds. I am glad that the Government is now dealing with this matter and after working hard to ensure that the new registered employment agreement framework is constitutionally robust. The bill makes provision for the registration of employment agreements between employers and trade unions governing remuneration and conditions of employment. The content of these agreements will be a matter for the contracting parties, and they will be legally binding on both parties. The bill also makes provision for a new type of ministerial order, the sectoral employment order, which allows the Labour Court to trigger a review of pay and conditions of a particular sector of industry and to make a recommendation to the Minister. Such a review can be initiated at the request separately or jointly of organisations substantially representative of employees and or of workers. There is broad acceptance that the reintroduction of the registered employment agreements will benefit workers and their employers. For workers and employers, these agreements and orders will provide certainty around what pay and conditions will be in the future as well. And this will provide, I believe, industrial peace in a recovering economy, and I think this is vitally important. I'm also pleased about Part 3 of the legislation, which fulfils a significant commitment in the programme for government to make sure that Irish law is consistent with the recent judgments of the European Court of Human Rights by providing a clear and balanced mechanism by which the fairness of the employment conditions of workers in their totality can be assessed where there is no collective bargaining agreement in the workplace. This legislation removes the right of access of what are called, I quote, accepted bodies, unquote, to procedures dealing with collective bargaining legislation. An accepted body is a term used in the Trade Union Acts to describe a body such as an in-house work committee or the like that is not a registered trade union and that conducts negotiations on pay and conditions only for the staff of one employer. Since the decision of the Supreme Court in the Ian Rodairn versus Holbrook case, it is now clear that a body cannot be an accepted body within the meaning of the Trade Union Act of 1941 unless it actually conducts consensual negotiations with an employer. So if there is a genuine accepted body in operation, that means there is genuine collective bargaining as well. The point of all this is to ensure that a body that is an in-house committee or similar that is merely serving as a window dressing to give pretence to collective bargaining is not allowed to avail of this legislation. It is also important to point out that this legislation is about providing a remedy where there is no collective bargaining. A fundamental reason for invoking this Act must be the absence of collective bargaining negotiations. That prerequisite cannot be satisfied where there is a genuinely functioning accepted body. If there is no consent under the legislation, under this bill, then the Act can be invoked. Section 24 inserts a new subsection into the Principal Act to give practical effect to the principle of the independence of an accepted body. It gives guidance to the Labour Court as to that criteria it should take into account in determining whether an accepted body is engaged in collective bargaining and is genuinely independent of an employer. Section 24 also amends the Principal Act by providing that where an employer asserts to the Labour Court that it is his or her practice to engage in collective bargaining with an accepted body in respect of the workers concerned, it will be for the employer to satisfy the Labour Court on this. The Government has decided, as a matter of policy, that it would be preferable for the workers involved in this dispute under this Act not to be required to make themselves known to their employer early in the process, if possible, so as to avoid any potential for victimisation. This new section provides that a statutory declaration can be made by the Chief Officer of the trade union concerned, setting out the number of its members and period of membership in the grade, group or category to which the trade dispute refers and who are party to the dispute. That shall be admissible in evidence without further proof unless the contrary is shown. I believe that the bill in its totality represents a significant step forward for workers and for employers. It provides a clear, workable and constitutionally robust framework within which workers' remuneration and conditions of employment can be discussed and determined. I know of cases where this legislation would have helped and supported workers who were horribly victimised because they were trade unions who sought to bargain collectively in the workplace. And those workplaces were very unfair places, and we've seen very recent examples of this. Because this legislation did not exist at that time, these workers were bullied into silence, sometimes made redundant under spurious circumstances, or constructively dismissed. I'm extremely proud to support this legislation, which has been the aim of the Labour Party for many years and which has now been finally been put into effect. I'm confident that this framework will fit Ireland's constitutional, social and economic conditions, traditions and its internal obligations, and that's very important. Will ensure continued success in creating jobs and attracting foreign investment into the economy. I warmly commend the bill to the House. Thank you.